On the DS160 and on the 260, you're going to provide things like 5 years worth of addresses, your social media accounts.
Welcome back to another episode of Visa Vibes, the podcast where we try to bring clarity to U.S. immigration laws, one episode at a time. I'm Emily Newman, managing partner of Reddy Newman Brown PC.
And I'm Stephen Brown. I'm also a partner at Reddy Newman PC. Here today, we're going to be discussing consular processing, what it is, how it works. Does anybody really know? What to expect at your visa interview, and common issues we see pop up throughout that process.
All right, so consular processing, it's all about visas. But what is a visa really? Because I feel like in the news and the media, everyone talks about visa when they're a lot of times actually talking about status, or they're talking about a petition or an application.
We have that issue pop up in court a lot. It's a colloquialism. People hear visa, that's what they think governs everything. We take away your visa, you got to leave.
Yeah, so not true. So the visa is actually the stamp that's in your passport. So you have your passport, you go to the consulate and say, I want to get a visitor visa to come to the United States. If they say, yes, you can come in, the consulate will give you your passport back with this foil stamp on it that has your picture. It says it's a B1, B2 visa. It has a issue date, an expiration date. It has a visa number on it. It has all kinds of little notations and things. And so that is the document that you will use when you are traveling into the United States. When you land at the airport, you go up to the counter, that's CBP, and they ask you, why are you here? You open up your passport to that visa page and say, here's my visa. I would like to come to the United States to visit for 2 weeks. Then they will issue you an I-94 card. You go on your way. The visa has nothing to do with your status. All it does is get you in the door of the United States. Once you're here, that I-94 that CBP gives you determines how long you can stay. It verifies that you've actually been admitted into an actual status. It verifies what class of admission that you are entered into. The visa has nothing to do with your status. It's your I-94 that controls. And if you're staying in the US and your visa stamp expires, that's okay.
Right.
You don't need it. The only time you need another visa again is if you leave the US and your old visa has expired, or maybe you changed your status to some other visa category. Now you need a new visa in that category to come in. All that is done through the consulate. So the visa does not have anything to do with your status. It doesn't decide how long you can be here. You're not, when you file something with USCIS, you're not renewing your visa.
Right.
You're not changing your visa. You're changing your status. You're filing a petition to extend your stay, application to extend your stay.
Yeah, and this is a common thing we see people, come to us with. I think I have a conversation once every couple of weeks that, hey, my visa is about to expire. I'm going to go travel to get it stamped and then come back in. And, no other plans to travel, just thinking that that's what they need to do. And that's not the case. I mean, how many times we see people with their visas expired because they've been here, more than the 3 years of an H-1B or whatever, or if they're on a new category. If you go from your F1 student visa to an H-1B, as many people are trying to do with cap season, you're still going to have that F1 visa, even though you're on H-1B. It just next time you travel and leave the U.S., you have to go get that stamp.
So what are the common forms that have to do with consular processing?
Yeah, so, like anything immigration, we've talked about abbreviations, form types, and all that. So let's kind of talk about them. We have 4 main ones that we're going to be addressing throughout our podcast today. So we have the DS-160. This is the non-immigrant visa application. So if you're looking for an H-1B, an F-1, a L1, an O1, a B visa, you're going to do that through a DS-160. The DS-260, not to get them confused, the 260 is the immigrant visa application. This is for green card applications. So if you're doing employment-based or an investor-based green card or diversity visa or family-based or immediate relative, you're going to do it through the DS-260 online. The 2019 is for J1 visas. The J1 visa program is more or less governed by Department of State, and so a lot of it is going to be done. All the terms and conditions are going to be through the DS 2019. The DS 5535 is our extreme vetting questionnaire. On the DS 160 and on the 260, you're going to provide things like 5 years worth of addresses, your social media accounts, where you've worked. This really saw a big increase the last, maybe it was even created during the last Trump administration, if I'm not mistaken, to do this extreme vetting. And it's going to go through 10 years of information. I remember a case, Emily, we had a 3-year-old get a DS 5535.
Asking for 10 years worth of addresses.
Yes, and social media
and
accounts.
History. Yeah.
The DS 160 with 5 years was not enough. We have to do the DS 5535 to cover the remaining negative, 7 years of this kid's life. So we're going to talk a little bit about the DS 5535 and kind of when it comes up later on. But those are the 4 main forms we have.
All right, so let's say I'm applying for a non-immigrant visa. So this is your temporary visa, your work visas, your visitor visa, that sort of thing. What is the process of consular processing to get that visa?
Yeah, so we're going to start with step 1. And then, 2 through whatever are all going to be the same. But for the majority of visa type, work visa types on these non-immigrant visas, H1, L1, O1, TNs for Mexican nationals, is going to start with an approved I-129 through USCIS. So you're going to file the petition, get it approved, and then start consular processing. And when we're talking about F1, B1, J1s, they don't require the petition. And again, excuse me, I said TNs. TNs don't require the petition. You just apply at the consulate. Once it's approved, you're going to do the DS 160. This is online through Department of State. Fill out all of the information. It's lengthy. It is very intrusive isn't the right word, but it is very in-depth on your background. Remember, the way the government kind of views it is that the consular officers and Department of State are that first line of national security defense. And so they're gonna, you're gonna fill that out, make sure you're accurate, and provide complete answers. You're gonna pay the fee. This fee is gonna be dependent on what type of visa and your country. There's a chart on Department of State's website, and then you're gonna book an interview through the consulate. Sometimes they're available immediately. Sometimes way down the roads. That sometimes gets updated with Department of State. Sometimes they don't update it. So schedule your appointment, gather your documents, your passport, your confirmation letter for the appointment and the DS 160, any of your petition approval documents, maybe a job confirmation letter, employer letter, some of these other documents that are needed. If you're on F1, bring documentation to show your ties to your home country, because that's a common ground towards a denial. But most importantly, we've heard from consular officers or former consular officers, it's the interview. And so after, when you get your interview, it's quick. It's, 5 minutes long. I always joke, it's kind of vibes-based adjudication. The officers typically don't go through, if you come in with a stack of paper, they're not going to be going through all of this. It's going to be based off of your answers and how they feel your answers are. So, for an F1 student, you could have, a giant book of how you have ties to your home country. But if the officer isn't feeling it that day, they could deny your visa. And we've seen it. I've seen people who get a visa denied and then go in a week later for another appointment and get it approved. Nothing's changed. It's just maybe how they presented it or how the officer interpreted it. During the interview, you're going to have really 2 things that can happen. You're going to either be told, hey, we're going to issue the visa and we'll get it to you in a day or a week, whatever the post is doing, or they're going to issue a 221G. We're going to talk about 221Gs later, but they can really approve or deny visas. So that is the non-immigrant side. Emily, the immigrant visa side, a little bit more complex, a little bit more ingrained here.
Yeah, there's a lot more that happens through this other entity called the National Visa Center. So, with green cards that are processed through the consulate, most of them are family based green cards, but there are some employment based cases that might go that route. So the first step is again going to be that USCIS petition approval. So under the family-based category, you need to have the I-130 petition filed and approved that confirms the qualifying relationship between you and your family member. And then if you are employment-based, you need to have the approved I-140 petition that proves that your company either has an approved perm labor certification and you qualify for the job, or that you filed under the national interest waiver, or maybe a Schedule A, or maybe a EB1 category, but all of those require an immigrant petition, either I-130 or I-140, to be approved by USCIS first. From that point, USCIS is going to ship your file to the National Visa Center, where they're going to basically act as a clearinghouse for all of the consulates all over the world to start gathering the documents, determine when a green card becomes available for you, and determine when an interview slot opens up at a particular consulate. So the NVC might get your file and then send you an email saying, we got your file, but there's nothing we're doing on this case because no immigrant visa is available for you right now. That means the green card is unavailable because your priority date is not current according to the visa bulletin and when you filed your I-130 or I-140. So they just sit on it. Assuming your priority date is current and the visa is available, they will first send you an email saying you got to pay us. So we're going to have to pay some visa application fees. Once the fees are paid, then you will log in again to submit the DS-260 visa application, which is very similar to the DS-160. A lot of the same questions, 5 years worth of address history, 5 years worth of employment history, all of your family information, your social media handles. Then a laundry list of yes or no questions. Are you a communist? Are you a terrorist? Are you a criminal? Have you been arrested?
Member of the Nazi Party between 1939 and 1945 is, we're dealing with 40-year-olds.
Right, yeah. So you submit your DS-260, and then depending on the type of case that you have, you may have to then submit an affidavit of support and pay an affidavit of support fee. This is generally for family-based cases where the person who's sponsoring you has to show that they have sufficient income to support you when you're in the US so that you don't end up becoming a public charge or go on welfare. There are some employment-based cases that need this as well. Generally, when there's a family relationship between you and the company sponsoring you, then an affidavit of support is needed. But in general, employment-based does not require that. But if you have to submit an affidavit of support on top of the form itself, the sponsor has to submit their financial documents as well to prove that they have that income. Now, on the family-based side, all of this is done through the SEAC system, all online, which is somewhat nice that it's online, but you have to have your files in the exact right format. They can't be too big, they can't be too small. One has to be in color, the other one has to be not in color, and so you can't combine things together into one PDF. So it's a little bit annoying from that standpoint. But for the employment-based standpoint, they don't let you upload documents. You actually have to mail them to the National Visa Center, which tends to lose them, or they have this cover sheet with this checklist that you have to check off. It's a very cumbersome process. I'm not a fan of consular processing for employment-based cases. And then you have to upload your civil documents. So these are your birth certificate, marriage certificate, divorce decree if that applies to you, military records if you were in the military, any criminal records, the biographic data picture page of your passport. And at this point, you have to get police clearance certificates for applicants over the age of 16 who, for any country you've lived in for 6 months or more, not counting the United States, so that they can conduct all of their background checks. All of that is submitted to NVC either by upload or mailing, and then they will tell you there's something missing. And then you have to go back in and add more, or tell you there's some insufficient. And once you get all through that, at some point they'll say you are documentarily qualified And if an immigrant visa is available to you and an appointment is available at the consulate, they will now send your file to the consulate, and the consulate will notify you of an interview date and time. You'll then be told to schedule a medical exam that's done in your home country, and then you show up to the interview. For that, you definitely need to be familiar with the petition that was filed on your behalf, how you qualify for this particular category, have all of your documents ready. Assuming that everything goes well, you'll eventually get your passport back with a stamp in it, just like the visa stamp. It's an immigrant visa stamp. And then you get a sealed envelope that you have to carry with you to the port of entry. They'll open that, they'll do whatever they do with it. And then eventually, once you're in the US, they will mail you a green card.
Okay.
But up until that point, you use the stamp that's in your passport as proof of your green card.
I think one of the most interesting things, like behind the curtains with consular processing, the green card, you said documentarily qualified, and they send it to the consulate. They're not, FedExing like a package. It's an email.
Mm.
And sometimes we see delays from NBC to, schedule that. So, you would think it'd be efficient, but
One would hope.
not really. I mentioned earlier, Emily, the interview, and I think this is the most critical part of any consular processing, whether it's an immigrant visa, non-immigrant visa. The consular interview is going to be make or break anything. No matter how good of a letter Emily or I could write, it's all going to depend on that interview. And, when we're talking about employment base, you really have to know what's going on. And you should. You should. But, review the petition. Maybe the company framed the job duties a little bit differently than you would have. Maybe they said, create instead of develop, and I don't think we're going to get stuck on words, but just kind of know what's in there, know what your job is, how you're eligible, and what you're expecting to be doing. Dress professionally. You don't have to, I don't think you have to wear a suit and tie kind of dress, but you are going to a government office seeking to go in there. I don't think I'd wear a graphic t-shirt, with something witty on it. And answer directly. The consular officers don't need, if they ask, hey, who's your employer? They don't need like a 10-minute thing. Just be direct. I work with Red Union and Brown PC. For work visas, know your employer's name. And that sounds easy, but we've seen instances where, whether it's a misunderstanding or whatever, somebody says, I'm working at, that they're working with ABC Inc., that's their employer, and they're doing work for Coca-Cola, and they say, oh yeah, I'm working for Coca-Cola. And just know the difference, especially for that. Know your job duties, where you're going to work, where you're going to be living, and all that. For family-based cases, be willing to discuss that, relationship, and how did y'all meet, how long y'all have been together, and all that as well, your plans in the United States. And, bring everything with you. I always tell people I'd rather you bring more with you that you end up not needing than less. That petition approval, the confirmations, the photographs, the passports, medicals, whatever it might be, letter from your employer, whatever, for this. So that way, again, if they need something, you can give it. But again, it's going to be based off of that interview. So, Emily, we've done the interview. What happens now?
Well, if you're lucky and everything went smoothly, you get the approval and you get your passport back in the mail, or you pick it up with the visa stamp in it. But if you are maybe not so lucky, you might get what's called a 221G. Sometimes they'll give you a little slip of paper. Sometimes they just tell you. It's an administrative processing. So 221G is actually a section of the Immigration and Nationality Act, the statute. And it is a refusal. It is a denial of your visa, but it is a temporary denial that can be overcome after the administrative processing has been completed. So it gets really confusing for people when later, after you've had this 221G and you eventually get your visa, now when you're filing an adjustment of status, or you're filing an I-539, or you're applying for a new visa, there's this question that says, have you ever been refused a visa before? 221G is a refusal, even though you got the visa after the 221G. So you do need to answer that yes. But basically, they're doing some kind of digging. whether it's digging on you, digging on the company, looking into relationship, sending it to the fraud unit. There's all kinds of things that they're looking at. In order to decide if your case actually can be approved after they first denied it. Sometimes they are reaching out. Let's say if you work for a consulting company and the consulting company said you're going to go work at Coca-Cola, they might reach out to Coca-Cola and say, hey, we got this letter. This guy brought this letter from your company saying that he's going to be placed at your facility. Do you know this guy? Like, is this a legitimate letter? Because some bad apples at some point were faking letters or modifying them. And so the consulate does send that letter to the end client and says, hey, is this legitimate? They also might be asking for that DS 5535, which is the extreme vetting form. So then you kind of have a better idea of maybe what's going on. There's something going on with the security check because sometimes they don't tell you anything. They just say you're in administrative processing. They don't ask for anything.
I mean, yeah. Sometimes it's literally just a piece of paper. It's got your case number, a case number at the top, and then it just is a checkbox next to administrative processing.
Yeah, and then sometimes they do a security advisory opinion where there's this technology alert list, and if you have something in your background that has dealt with that technology, like sensitive technology, like maybe you worked in a lab as a microbiologist and they're worried about biological warfare, and do you have anything in your background that could let you come into the US and do some nefarious things, they will do a separate security advisory opinion. For that, they'll typically ask you for your CV, your resume, your projects you've worked on, what you're going to be doing in the US. It's not quite the DS 5535, but it's a similar extreme vetting there and takes a few weeks to process. But for just a regular run-of-the-mill 221Gs where you don't have any information, it can take months. Yeah. And you can keep following up every 60 days or so, every 30 days. And a lot of times it's just a black hole. You don't get a response. Sometimes you'll get a response just saying, we're still in administrative processing. And that's when you may need to look at lawsuits.
Yeah, and litigation on 221G is very interesting because of the fact that the plain language of the statute, the header of the statute is that it's a refusal. You really have a judiciary that is confused on how to treat these. There have been some judges that are like, wait a minute, you can't just call it a refusal when you're still processing it. And therefore, because you're still processing it, it's not a final decision. And therefore, we don't have to go with consular non-reviewability. So we can look at, is this reasonable? There are other judges that are like, it says refusal, like consular non-reviewability applies. And I had a very frank conversation with a U.S. attorney when I was in D.C. Last month. And he's like, we don't need, it's really judge by judge. So I think needing to go in and understanding how these cases can go and be prepared to maybe have to fight it out. Because, again, I've seen some judges go very different ways because it says refusal, but there are some judges who are like, how can you call it a refusal if you're still processing it?
Yeah. So, what can you do to avoid a 221G? Mainly just be prepared for the interview. Understand what the visa category that you're applying for requires. Understand which category requires, proof of non-immigrant intent. I always tell clients when you're going for your interview, because it's such a short period of time, create like an elevator pitch, a 30-second introduction into yourself and why you're there today, what you're applying for, and how you qualify. And then let the consular officer follow up with any questions they may need. Sometimes a 221G can't be avoided. Sometimes it's something with the company. Sometimes they're just doing that fraud review or sort of thing. But sometimes they can be. Sometimes they are triggered by dumb things people say in an interview.
Yeah, and I've got, you talk about being prepared. I mean, I have a corporate client that especially when people are going for their first interview, they, have their key leadership and me on. We kind of do a mock interview, and, the company's tougher than I am. They want to make sure, they're explaining things in a concise way as well. But it really is, how you sell it, yourself. And it's that elevator pitch. They don't want this 10-minute explanation of the technology you're working on.
All right, so 221G is one outcome. Mm-hmm. What about a 214B?
Yeah, so this is the most common ground for denial. Especially when I'm talking to people with B visas, F1, J1. I mean, if I get an email that says my F1 got denied, what do I do? If I guess it was 214B, 99% of the time I'm right. This really, is kind of a catch-all reason. It really focuses on you not having enough to show your ties to the home country and that immigrant intent. They sometimes also use it if they think you're not really qualified for that job, or what you're coming in for is not really qualified, especially on the B visa side. They'll use it. Common things we see, with the ties to the home country, young, unemployed, you don't have property, you don't have family there, maybe all your family's in the US. And so again, it's really about how you explain it. But I also see it when things are very clean. I mean, there is no appeal on these, but you can still reapply. I had a case earlier this year, a lady whose husband lives in the home country, her kids live in the home country, everybody, all of her family does. She was coming in to kind of finish up some education. 214B, gets another consular appointment 2 weeks later, gets the visa. So it really is kind of officer dependent, and how they're kind of feeling that day. Get them when they had their coffee. But yeah, it's frustrating because it is just, again, it's a checkbox. They'll say denied 214B, and they won't say we don't think you have enough ties because da 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 da. They just, you got to go figure it out. So this is where kind of interview prep, whether it's talking with friends who've done that interview or attorneys or looking at, kind of best practices from other people really comes in handy. So 214B is one ground. What's 212 all about? All of our other.
Right. So with both immigrant visas and non-immigrant visas, there are grounds of inadmissibility that were decided by Congress when they passed the Immigration and Nationality Act. Inadmissibility means that you are not allowed to come into the United States because of X reason. And there are a limited number of these reasons. They're very specific. So one of them is if you have been unlawfully present in the United States for more than 180 days, you are subject to a 3-year ground of inadmissibility. If you've been unlawfully present here for more than 365 days, now you're subject to a 10-year ground of inadmissibility. That means you cannot receive a visa for 3 years or 10 years under that category. Another ground of inadmissibility is if you have previously submitted fraudulent document or previously misrepresented yourself in a material way for an immigration benefit. Maybe you showed up to your visitor visa interview and said something completely wrong. I'm going into the US to visit my brother. He's getting married, and that was all fake, and there's no brother, and whatever it is. And never do these things.
Yes. Yeah.
Fraud and misrepresentation, don't touch it.
I always tell people, like, there's a lot of things we can clean up. 214B, we can try to work with you, or if there's a refusal, whatever. Fraud and misrepresentation is a really hard one.
Yeah. So stay away from that. But there are also criminal grounds of inadmissibility. So, which is kind of a lot of a hot topic right now with everything going on with student visas, because as we talked about before with that, the things that the students were losing their visas over were not grounds of inadmissibility. Yeah, they might have been arrested for a crime, but they weren't convicted of a crime. Some of them were parking tickets, not even crimes. They're not ground of inadmissibility, but there are set grounds of inadmissibility, like anything dealing with a controlled substance. Marijuana, stay away from it. It is a ground of inadmissibility. You can be denied a visa, you can be denied a green card if you do anything related to marijuana. Murder.
Yeah.
Crimes involving moral turpitude, CIMT, which that one's a little tricky because there's, each state has different criminal statutes, and in some states, some things might be a CIMT, in other states, they might not be based on how they're defined. And so there's not one list of all crimes involving moral turpitude. So you have to look at what the statute, the state criminal statute says figure out if it meets the elements of a CIMT in that particular state and then analyze from there. Um, Beyond that, public charge is a ground of inadmissibility. This was a big topic under the first Trump administration because he wanted to change how we decide who is a public charge. So when a consular officer is looking at this person who's going to come in on a visitor visa to go undergo medical treatment, well, do they have the funds to support themselves so they don't use our government welfare in the US? Now, of course, immigrants, non-immigrants generally don't have access to any of our welfare anyways, but so he wanted to change all of that. He wanted to make you fill out these extra forms and look at your credit history and proof of health insurance and all these crazy things. It eventually went away, but public charge has always been there.
Yeah.
It's still there. It's just looked at more holistically, not like all these documents required. And then there are some health related grounds of inadmissibility. If you have some sort of communicable disease, you may not be allowed in. Now, with an immigrant visa, that shows up on your medical exam.
Right.
But it's always funny to me with a non-immigrant visa, if you're coming in for a visitor visa, there's no medical exam that has to be done.
That came up with the COVID vaccine. The green card side, the immigrant visa side, you have to get a medical with your immunizations. And, you had to, one of them, was the COVID-19 vaccine. And there was a lawsuit where an individual was denied her immigrant visa, went abroad, got a B visa, and entered in. And there were no issues without her having the COVID vaccine for the immigrant or the non-immigrant visa, just the immigrant one. And there were other arguments about whether it was a vaccine preventable disease based on some of the current science out. But yeah, it's really funny that there's all these vaccines you have to get or have for the green card, but not the non-immigrant visa.
Yeah, so people come in, they've been here for years, and then all of a sudden they get the medical exam done, and you've got some
It's so bizarre.
So if you are subject to one of these grounds of inadmissibility, all hope may not be lost. There may be a way to waive the ground of inadmissibility and still receive a visa.
Yeah, so there are certain waivers that are available depending on your situation, the ground of inadmissibility. For example, you can never waive a national security issue. You might be able to go through and kind of get that corrected. I always joke, my younger brother, when he was like 5 or 6, always showed up on the do not fly list. Like somebody with the same name. We always had to deal with that post 9/11. But maybe there is an instance where you're getting flagged for no reason. But national security generally can't be waived. But let's talk about some of the things that can. So for non-immigrants, there is what is called the 212D3 waiver. This is coming from the INA, section 212, subsections D, subsection 3. Is a general discretionary non-immigrant waiver for most categories of inadmissibility. It is referred to as the Haranka waiver, Hranka, because there was a decision from the Board of Immigration Appeals, matter of Haranka, that kind of set out the factors that officers should look to. Now it's in the Foreign Affairs Manual as well. They're going to look at the recency and seriousness of the issue that caused the inadmissibility, the public benefit to bringing you in, and then kind of some of the other factors that are around your admission. When you have an inadmissibility for a non-immigrant visa, you can do what's called prepare a waiver. There's for most inadmissibilities, there's not a form. You would just take in, a brief done by an attorney, maybe put in some stuff in your DS-160 that says, I'm inadmissible because of this, see brief, to clue the officer in. You're going to get a 221G because they can't adjudicate it right there. You're going to present this brief that goes through all the factors, goes through making those arguments for you. They're going to send it. The officer makes the recommendation. They're supposed to make the recommendation that you're applying just for the right one. Sometimes they go a little like, hey, we're going to not even recommend it. But if they recommend it, it goes to CBP for ultimate approval with the Admissibility Review Office. And this could take a while. It's not instantaneous for sure. But it does help when we're talking about some of these permanent bars, or, if you've got the 10-year bar, The I-212 is done with CBP when you have expedited removal. It's a 5-year bar. You would still have to apply through the consulate, and then they send it over to CBP. On the immigrant visa side, the green card side, you have the 601 and the 601A. The 601 is kind of your general, hey, I'm inadmissible. Maybe it's fraud, maybe it's, the criminal grounds, and you're seeking a waiver. 601A is unlawful presence, and this is kind of created as and I can't remember the actual term, but you would do it while you're here to get the approval so you could go to the consulate and get your visa, because that bar doesn't trigger really until you leave. Now, with the D3 waiver, the non-immigrant waiver, there is no question about hardship or anything like that. Now, that can be factors that throw in, especially when we talk about public policy. But on the 601, 601A, you have to show extreme hardship to a U.S. citizen or lawful permanent resident spouse or parent. Kids don't count, which is weird.
Yeah.
I think there'd be more of an interest in like the hardship to the kid than a parent.
Yeah.
But
well, you wouldn't want to help out people who had anchor babies.
yes, yeah. So those two waivers, and again, the big thing to remember, these are discretionary, so they can just deny it. But there's also good arguments you can make throughout these. And we've done some. They're kind of weird to navigate because different consulate posts go about it different ways, and but they do work. There is also the 212H waiver for certain criminal convictions, especially on the marijuana side. You have to show the rehabilitation and hardship, but I'm going to both say like stay away from the marijuana stuff because it could impact non-immigrant visas, immigrant visas, potentially your citizenship even. And we're not talking, using it and being arrested. I mean, we've seen instances where people have worked for companies that sell it, or state projects so waivers are available. Not everybody qualifies for a waiver, and it's something I think you should discuss with your attorney, but they can be there, and sometimes it works. Sometimes it might be worth it to wait. I mean, I had someone a couple of years ago, it was like 2.5 years into the 3-year bar, and kind of talked about maybe just wait it out, because by the time it gets through, you'll be at the 3-year.
Yeah, the waiver processing time is extremely long right now. Well, hopefully consular processing isn't quite as mysterious as you think now that we've broken it down a bit. You have to know the forms, prepare your documents, have your elevator pitch, and go in with confidence.
Yeah, and if your case is denied or delayed, there might be options available. You can still look through those waivers and potential litigation, and maybe we'll discuss more on the next episode of Visa Buys.
Yeah, so be sure to subscribe and tune in next time as we explore another corner of U.S. immigration world.
Thanks, everybody.